Now, the Imo State People's Democratic Party ousted governor, some will argue he was never a governor, Emeka Ihedioha, will tomorrow, actually he's presented his appeal to the hearing of the Supreme Court. What it is that the Supreme Court will be hearing that appeal tomorrow.
Yes.
The ousted governor is still seeking redress to the verdict that removed him from office and installed Senator Hope Uzodinma of All Progressive Congress. I mean, he was a governor, he took the oath of office. So, truly fictional.
That's another
argument.
From the look of things, it seems the controversy surrounding the Apex Court's ruling will not be going away anytime soon. So joining us now to discuss this is legal practitioner Joe Nwokedi. Welcome to the morning show. Now, after weeks of protest, the Supreme Court has agreed to review its January 14 verdict as to look into Ihedioha's appeal. I mean, tomorrow all eyes are going to be looking at the Supreme Court. What are you expecting to come out from tomorrow?
I have to first and foremost commend them for deeming it fit and appropriate to revisit that decision. Because in most cases, when you bring such application to Supreme Court, they might even throw it away. They might even tell you it's not worthy for them to look at it. At the registry, it will be like thrown out of, out of their cases.
It's too sensitive.
The cases they look at. So for them to admit and then agree that the issue ought to be revisited is something that we should commend. Then considering weighty allegations, weighty issues, I mean, something controversial issues raised after the election, after the judgment. I believe Nigerians will be like looking up to something positive tomorrow. Because that judgment, we have been having series of judgments in Nigeria. I'm a lawyer, we've been following up judgments. No judgment has actually drawn a kind of controversy, kind of reaction, a kind of, review. And even ordinary people, when people that we regard as being educated, begin to review judgments given by the apex courts, lawyers will feel ashamed. Because even ordinary people come on the stations, media platforms, castigating the Supreme Court.
When you say Nigerians should be expecting positive, as a legal practitioner, does a review by the apex courts of the land translate to a reversal or a setting aside? What do you mean by positive reaction tomorrow?
There are grounds that the court might review a judgment that emanated from that same court, even after judgment has been given, on the ground of fraud, on the grounds of non-service, on the grounds of lack of jurisdiction. So in the present case, you cannot raise the issue of non-service. They were properly served. You can't raise the issue of having no jurisdiction. The Supreme Court of Court has jurisdiction. I think they can come by way of fraud. A court can set aside its own judgment by way of fraud. I don't know whether it's applicable to the Supreme Court, but the fact that they raise the issue that they believe that Supreme Court did not look at, or Supreme Court was a kind of not well guided in looking at, or out of maybe because of time frame or whatever, that there was something that was shrouded in certain kind of coded exhibits that Supreme Court couldn't advance their minds to. So they are now bringing that by way of, okay, look at, you couldn't advance your mind to this place. And because of that, we want you to look at this. Maybe why considering this judgment, you didn't look at this.
Okay.
So that's why they have gone back to Supreme Court, and Supreme Court considered it worthy. Look at it.
When we talk about review, we always cite the Adegoke case, which has become a template for you to review by the Supreme Court. And the big word there, apart from just Chukwudi Foputas, that it's not fallible because it's final, but it's fallible because it's infallible, the big word here is par incurium. So in this, when you look at these prayers, I mean, does it mean, because constantly we keep putting that word aside. At first, so to the lay listeners out there, can you explain the concept of the par incurium here, and also now take it further and start to look at these prayers?
Yeah, because if the judge is done par incurium, it means that there are certain things that ought to be done. It was not considered very, very appropriately. It was done in error. Do you understand the point very well? So in that case, Supreme Court might look at it. If a judgment was delivered par incurium, they might look at it. They might look at issues raised.
But it's not just only was done in error. Par incurium simply in juxtaposition with the available laws. Is that not what it means? You can't bring... It has to be within the context of the law that was not seen before.
No, Supreme Court is our best court. They have what is called judicial case laws, judicial precedents. So, I mean, and most cases are not on all fours. What we mean are not on all fours, they're not 100% the same facts, the same issues canvassed. So where there is a little bit deviation, a little bit a kind of a new element or ingredient that came up in the new matter that may not be in the other matter, the court can still shift a bit. And then, then deciding cases based on what has been. It's always looked up to. But at a certain level, another case might come up where Supreme Court might not rule in line with what they have ruled before. It might be like circumstances that were prevalent at that particular point in time might no longer be prevalent now. Might be that issues considered then and are no longer what is like paramount in the societal consideration in the present time. And the Supreme Court might deviate from that. And whatever the decision of the Supreme Court might be is what the lawyers will follow. That's why in most cases you look at the most recent decision. The most recent decision of a case. When lawyers cite their cases, judges always ask you which year. Just when we cite so and so and so and so, so which year? So you said 1989. I said there was a judgment that came up in 1990.
That's a procedure.
Yes, it's the name of 1990. And like I said, we have recent decision of the Supreme Court, 2001.
That's why it's a book, it's a court of records.
2001. So what my learned colleague is quoting is a judgment that was delivered in 1980 something, but we have a current decision of the Supreme Court on this. And court will look at that most recent decision.
Okay, but what say you to the fact that even as it stands, both parties have not been able to achieve the constitutional spread of 25% in 2/3 of the states? And also, just to add to that, as it stands now, there are other parties contesting the fact that their numbers were not represented in the results. Even though they're not the ones that are supposed to go up next, all the results of parties that contested should have been put forward, as opposed to it being just between APC and PDP.
In the general the election that all the parties participated, I think about 70 political parties participated in that election. The results of other polling units reflected the scores by the parties. It's only that of 215,000 votes, 388 polling units, that only reflected PDP and APC. And they excluded 68 political parties. Even if they couldn't score a single vote, just put nil. Let there be something to show that they actually participated. Yes. Let there be nil. That's why sometimes when somebody wants to even go unopposed, in most elections in school, then they'll say everybody should come out and vote yes. Even if he's going unopposed, come and indicate that you wanted him. Do you understand my point? Some might see come there and put nil. Although he's going unopposed, we don't want him. Although the other party did not want to feel a candidate to challenge him, but we don't want you. They'll feel no. And the person will not go, although he's unopposed. So it is apposite for the scores of political parties to be reflected in the result sheets. Even if they have scored nothing, indicate they scored nothing. But that disputed result had nothing for the 68 political parties, showing that they did not even participate. These are the issues that people are looking at. People look at. Very questionable.
How come?
How come 70 political parties participated in the election? Only 2 political parties scored votes in 388 polling units.
But in our principle of law, isn't it correct that a fact that is not disapproved has been deemed to have been admitted and requires no further disproving? Isn't it correct?
Yes.
And if that is the case, what do you say to those who argue that Mr. Ihedioha and the PDP did not disprove the result Governor Uzodinma brought from the 388 polling units? Also, they say INEC, who is the custodian of those results, also did not disapprove or disprove those results. Would this not be an academic exercise and re-litigation for the Supreme Court, which the Supreme Court frowns at?
INEC actually did not say that INEC did not approve. Somebody testified from INEC. You know, this is appellate court. You know, people always get confused over these issues. Appellate court has to do with what actually originated from the lower courts. Okay. So someone has testified at the lower courts. These are what makes up the case. Records of appeal. You get all the arguments canvassed at the lower court and upload them to the higher court. In most cases, it doesn't even bring new elements at the higher court, because higher court might not want to bring us here fresh application that we are not met at the lower court. So INEC testified, at the tribunal INEC testified. But they said they couldn't have enough people, they couldn't call enough.
So
somebody from INEC testified, and no, he testified and said that those results are false.
By tendering the real
that
results,
the results, no, he that alleges must prove.
Did they prove?
They don't allege. It was Uzodinma that was alleging that he obtained a valid result.
But they did not counter with what they say.
No, INEC said they were not real. They may not go ahead to present it. It is what
is it enough to say?
It didn't emanate from us. We don't know where he got it from. And they are the authority that has the power to determine whether a result is emanating from
them. But that was a valid authority too. P51 was a police officer, was an arm of the law, was a part of the law. P54.
The police officer.
The police officer was the one that brought the evidence.
It's not, but the police officers are not authorized under the law to supervise, monitor, and regulate the conduct of elections.
But why was he admitted by the Supreme Court?
That was one of the errors people are looking at. And he was subpoenaed not through Inspector General of Police. He said a colleague served him the subpoena. The subpoena that brought him to testify did not even follow the regulations of the police. Because if you want to serve police, you have to serve their legal department. Legal department will look at the content of what you have served and then call the police officer in question, look at what is before you, and then guide the police officer how to go about that. But in the case of the Deputy Commissioner of Police, he was subpoenaed personally.
Are you saying
he couldn't even...
Are you saying the Supreme Court couldn't have dismissed this?
That is where these are the reasons why the matter has gone back to court. Can a police officer testify in an election he did not conduct, he did not supervise, he was not a party to? And then
was he not a party to that election?
He's not. He's a security.
He was a security
agent. Yeah. Security agent is not a party to whatever transpires in the election. Their own is just to monitor and then guide people and make sure we have law and order.
How can he be a witness to what
they don't monitor people as they vote. They don't check ballot boxes. They don't check who voted or who didn't vote. They don't even talk to you. If you have participated in the election, they don't talk to you. Just greet them. They are by the side. You meet the electoral officer that will guide you, vote, say, put your thumbprint, say, do this and do that, go and vote for senatorial, for presidential, for government, for House of Assembly. They direct you. Right. And at the end of the day, they count the results.
Mr. Joe Nwokedi, stay with us. We'll go on a quick break and back talk some more about some of the facts that are emanating from that judgment by the Supreme Court. Stay with us. You're watching The Morning Show here on the Rise News. Great to have you back. We're still discussing with Joe Nwokedi, a legal practitioner, over the hearing of the judgment of the Supreme Court over Imo State and indeed Bayelsa tomorrow. Tomorrow is the due day. Yes. But let's stay a bit on Imo State before we digress a bit to Bayelsa. Shaita had mentioned earlier the issue of the spread and those who brought in the issue of the spread. Do you think that this is something the Supreme Court should consider? Have you seen the prayers of the PDP, first and foremost, to start with? And what are their chances? And secondly, I'd like to have a bit on that spread because, again, you do know Section 179 of the Constitution, subsection 2B, and what it says. Some lawyers have argued that neither men, that's Hope Uzodinma or Ihedioha, had the spread of 25% at least in two-thirds of local government. In the case of Imo State, it's 27 local governments. So any winner declared should have had at least an 18. What we have on ground is 14 for one gentleman and 2 for the other gentleman. Do you think that this is enough for the Supreme Court to declare perhaps a rerun tomorrow?
It depends on what is before the court. In most cases, court is not, they always say they're not for the Christmas. To award you what you didn't bring before the court.
It's not a shopping mall.
It's not for the Christmas.
No supermarket.
It's only on a real occasion that courts can go on a frolic. We call it a frolic, to award you what you didn't argue before the court.
Exactly.
So they don't ask what is not contained in your prayers, on your pleadings. So that case now might be like getting into intellectual voyage, or judicial kind of exploration. But if they want to do that, good and fine. For them to save themselves from this presumed battered image, because that judgment roared all over the whole world, not just in Nigeria. They might come up and do that as an escape route. But is it what is before the Supreme Court? Actually, the answer is no. And the party actually go for that. Was the matter before the Supreme Court on spread? That he didn't meet that basic requirement of two-thirds in every
government. There are 8 points in Ihedioha's prayer.
Yes. Is that what is before the court? Are they asking the court to nullify the election? Are they asking the court to declare them the winner of the election? Are they coming by way of spread? That was Section 179. So I've not seen Supreme Court doing that. But someone can still bring up that issue before the court. You know, litigation has no end. Yeah. It has no end. Just I cannot bring the same issue before a court twice. They can still come up with another issue. For having that issue of that spread that's contained in our constitution, someone can come up and institute action on that, look, in as much as Supreme Court has declared this young man winner of this election, there's still another issue. He didn't meet constitutional requirement of the spread. And court will still, it's a valid petition before the court. Court will look at it and also rule on that. But in that case, court might declare fresh election.
But why would INEC even call an election in a case where somebody didn't meet the constitutional spread? It starts from there. Why didn't INEC even call for a rerun in the Imo elections? Because we knew the antecedents of that Imo election. That was the same election that the electoral officer in the senatorial elections with Rochas Okorocha was shouting that I'm announcing the result under duress. And Okorocha is a senator today. So we knew the antecedents of that election. Why will INEC have called that election in the first place?
INEC, in most cases, they have a certain time frame within which to conclude the election.
They have a certain time frame, but they called for a rerun in Osun State.
Yes, so because Osun case is like not a similar case with this. In Osun case, the margin was
closed, but in this case too, there was no clear winner.
The margin was closed. The margin was 300 and something votes thereabout. At this place, you have a margin of almost 8-something thousand votes. Just my point. They can declare a winner because even if election has been like conducted in these places, with all the results or whatever that we have mandated from that place, from result sheet, cannot nullify, meet the margin of the votes. The other person gave the person that came second. But in Osun election, we have about 1,700 something votes cancelled, and 300 something votes with the person lead that Adeleke was leading Oyetola with. So you cannot bring in Osun a kind of issue situation here to that of Imo State. But like issue you rightly noted, INEC can as well say, okay, because there was no spread, and then again, have they actually been encountered with that kind of challenge in the first place? Has INEC actually nullified the election because of spread? Have they done that in Nigeria? And so you should know. So I believe they might have left that vacuum for the court to decide. That look at the person that polled the highest number of votes. We are declaring you winner.
I mean, if
anybody feels aggrieved that there is a constitutional issue to be determined, go to court. Court is always there to interpret that. That was the case of Awolowo versus Shagari. So then you go there, and Shagari has been declared president before that issue came up. INEC then, of Fedeco or whatever the name was then, did not nullify that election on that ground. He still go ahead to announce Shagari as the winner, having polled whatever they have then.
There was a second part to my question when I asked you about the chances of Mr. Ihedioha and the PDP in Imo State concerning this review we're about to witness tomorrow. How high, how low are the chances from what you've seen so far? Some have referred to the case of Lawson and Johnson in 1971 when the Supreme Court did declare for a rerun to take place. Is that what we're likely to see tomorrow? What are the chances?
Don't think that Ihedioha has chances of that election being revisited, that judgment being revisited, either in the form of re-election, in form of fresh election, but not basically in form of authenticating that judgment by allowing Uzodinma to remain the governor. That would be a deadly blow to our electoral processes and then to our judicial precedents.
What if it happens?
It will not happen. I am confident that it will not happen.
What if it happens?
Although I have that belief. I'm not the court. I cannot preempt the court because we have glaring factors. Yes. I said it has to do with figures. Yes. When issues are dependent on legal arguments, lawyers and judges can maneuver and manipulate things. I will just say it here. We can canvass issues. It's our work, and judges can also come in and then destroy you as a lawyer.
The lawyers are also the problem.
No. The issue is that judges can even, the way they will give their judgments will surprise you. But in my election, you have the figures there.
Yes.
Total number of legislative votes has 254.
That was actually
then you look at the PVC collection.
Let me just really come in, because that was actually going to be my next question, talking about this rerun. Because if we look at the numbers, the number, like you said, of accredited voters was actually 823,000 plus. And by the time they included the votes for Hope Uzodinma and Emeka Ihedioha, it came to a total of an excess of 129,000 votes.
Yes.
So my next question to you is it not unlawful for the total number of accredited voters to be less than number of actual votes on ground?
Come from. That's where that burden is on Hope Uzodinma. We're plot with Sinek and Ihedioha should go and get a result. I say, wow, no. What you have before the court, proof before the court, they're authentic. It's same material whether the other person has gone out to. After all, election petition matter is like quasi-criminal cases. Quasi-criminal, not wholly criminal, but not wholly civil. They are quasi-criminal. If you allege that something happened, you have to prove the occurrence of that thing. He that alleges must prove. What Hope Uzodinma brought, assuming but not considering to the fact that those results are like INEC has them, can they be more than the number of votes accredited? Number of PVC collected? The excess vote you have, where did they come from? Let us even assume that, yes, there were votes that were voted there. Explain to the court, and once there is a doubt, remember, once there is any doubt, the court rules in favor of the other party. If you fail to prove beyond reasonable doubt, in any matter that has to do with things of proof, the court resolves the issue in favor of the other party, irrespective of whether he has actually tried to disprove you or not.
I quickly want to take on this. Let's talk about the international dimension. You talked about an international dimension. And there's a report that came out about America looking into this and looking about a couple of judges and saying, you know what, investigations are still on, but we might stop them from coming into America.
Yeah, because some people are saying that Nigeria is a sovereign nation, that they are not, America should just mind their business. And I said, look, they cannot mind their business. But we have treaties, we have international conventions, and Nigeria is secretary to most of these international conventions, Universal Declaration on Human Rights, and so many conventions. Even if you said a lot of ICC, why are they trying people of different countries? The people that spoke in America might be like they're creating awareness to the world. For appropriate authority, and even American
and they
government.
mentioned Igbo.
Yes, to do something. Because they reviewed the election. What actually gave everybody concern in that election is the figures, and never talent.
Yes.
If the figures had actually talent, you might say, okay, let's just presume that it all happened. The figures don't tally. Where did you manufacture the votes from? Okay. You have 254 votes, registered votes. You have PVC collected 201, and then you have the number of voters, 215. You see 201 people that collected their PVC. And you know Nigerians, they may collect PVC and 30% will not vote. Will not vote. And now you even have number in excess of people that collected their PVC. Had Hope Uzodinma, has he convinced the Supreme Court where those votes came from?
Okay. That means voter turnout rate was over 100%.
That means there was fraud. There was fraud. And when you have issue of that nature, courts cannot go ahead to validate that fraud.
Well,
so what happened in that Supreme Court is that people believe the Supreme Court validated fraud perpetrated by Hope Uzodinma, and it cannot stand.
Let's leave it at that. Tomorrow is only a day away, and we'll watch and see that proceedings. Thank you so much, Mr. Joe Nwokedi, for coming on the show today. And that brings us to the end of the show today as well. I am Ade Stoa Omoran.
I'm Rafal Yosedi.
And I'm Shaiton Atigari. Thank you so much for watching. You can also follow us on all our social media handles showing now on the screen, with live streaming, of course, on arise.tv.